Okay, let's dive in. Imagine you're facing a criminal charge, right? But something about the accusation, the actual document, feels off.
Yeah, like maybe the details are just wrong or the law they're citing doesn't really fit what they say happened.
Exactly, and that's where a really crucial defense tool comes into play, the motion to quash.
Mm-hmm. It's governed by Rule 117, mostly. And legal experts, people like Willard Riano and the Supreme Court itself, they see it as a kind of gatekeeper.
A gatekeeper, I like that.
Yeah, it lets you challenge the whole foundation of the case before you even get to pleading guilty or not guilty.
So this deep dive today, it's kind of your shortcut to understanding this safeguard, how it works, why it's so important, and some surprising details.
Right. It's about making sure you only have to face accusations that are actually, legally solid.
So fundamentally, what is a motion to quash asking the court to do?
Basically, you're asking the court, dismiss this charge because the complaint or the information, the document outlining the charge has some kind of fatal flaw.
A fatal legal flaw in the paperwork itself.
Precisely. You're saying, look, this document, it's legally defective. It's not about arguing you didn't do it. Not yet, anyway.
Ah, okay. It's about whether the charge, as it's written, holds water legally.
Exactly. It protects your due process rights, makes sure the charge clearly tells you what you're accused of, and that it's an actual crime recognized by law.
So it can stop a weak or flawed case right at the beginning, save everyone time.
That's the goal. Stop flawed cases early.
Okay, so timing must be pretty important here. When does this motion need to be filed?
Oh, absolutely critical. The rule is crystal clear. You must file it before you enter your plea.
Before the plea. Why so strict?
Because pleading, saying guilty or not guilty, generally means you're accepting the charge as written for procedural purposes. It waives most grounds you could have used to quash it.
So you lose your chance for most issues if you plead first.
You do. It forces you, or rather your lawyer, to scrutinize that charging document right away.
But what if there's a really fundamental problem? Something major? Are there any exceptions? Can you raise it later?
Ah, yes. And this is where it gets really interesting. It shows the system cares about core rights. There are exceptions, the non-waivable grounds.
Non-waivable, meaning you don't lose the right to raise them, even after pleading.
Exactly. These are flaws considered so serious, so fundamental that you can raise them at any stage, even, believe it or not, for the first time on appeal.
Wow. Okay, what kind of flaws are that serious?
Typically, they involve things like the court's basic power to even hear the case, what we call jurisdiction, if the court simply has no legal authority over the crime charge.
Makes sense. What else?
Or, and this is a big one, if the facts alleged in the charging document, even if you assume they're all true, just don't add up to a crime under the law.
Can you give an example?
Sure, the classic example is something like being charged with stealing your own property. Legally, you can't steal from yourself, so the charge fails to state an actual offense. That's non-waivable.
Okay. Any others?
Yeah. Also, if the criminal liability has been extinguished, maybe the time limit to prosecute, the statute of limitations or prescription has run out, or, crucially, if prosecuting you would violate double jeopardy, meaning you've already been tried for that same offense.
Those exceptions really underline that this isn't just about ticking boxes, it's about fundamental fairness.
Absolutely. It shows the system recognizes some errors are just too important to ignore no matter when they're spotted.
Yeah. Now, the rule mentions other grounds too, right?
What?
More technical things.
Yes, there's a list. Things like defects in the form of the charge, maybe how it's worded, or if it improperly lumps multiple offenses together. Those are usually the ones you do waive if you don't raise them before the plea.
And what about the person who filed the charge? Their authority.
Right, that's another ground. And recent court decisions have drawn a line there. A complete lack of authority might potentially be a non-waivable issue, but a simple procedural slip-up in filing. That's likely waivable. Shows these rules aren't static.
Okay, useful distinction. How is this different from something like a demur to evidence? People sometimes confuse procedural moves.
Good question. They happen at very different times and challenge different things. Motion to quash before a plea challenges the legal validity or form of the charging document.
Right, the paperwork.
Yeah. Demur to evidence happens much later, after the prosecution has presented all its evidence at trial. It challenges whether that evidence, the proof offered, is actually strong enough to convict beyond a reasonable doubt.
So paperwork versus proof presented in court. Got it.
Exactly.
So what happens if you file a motion to quash and the court actually agrees with you? It grants the motion. Then what?
Well, the case against you, based on that specific flawed document, is dismissed. Now, if the flaw was something minor, like a fixable error in form, the court might allow the prosecution to amend the document and refile.
Okay, so they might get another shot.
They might. But if the dismissal was based on one of those non-waivable grounds we talked about, like double jeopardy or the crime being prescribed, then that dismissal is usually final for that charge. It acts as a permanent bar.
A permanent bar. Okay.
Okay.
Now, I also saw mention of provisional dismissal in relation to this rule. How does that work? Is it the same thing?
No, that's a different animal, and it's important to distinguish. Provisional dismissal needs the consent of the accused person, and it comes with time limits, typically 1 year for lighter offenses, 2 years for others.
Consent and time limits. What happens after that time?
If the prosecution doesn't revive the case within that specific time frame, it stays dismissed provisionally. But, and here's the key difference, unlike a dismissal for double jeopardy or prescription, a provisional dismissal does not automatically mean acquittal. Meaning it generally doesn't permanently stop the prosecution from filing a new information later for the same offense, provided the overall statute of limitations for the crime itself hasn't expired. It's more like putting that specific case file on ice, not necessarily ending the threat of prosecution entirely on those facts.
Okay, that's a really crucial distinction. Provisional dismissal isn't the same permanent shield as a dismissal on, say, double jeopardy grounds.
Precisely. It's often misunderstood.
So, wrapping this up, what's the big picture here? The main takeaway for you about Rule 117?
For me, it's that this isn't just some dusty legal formality. Rule 117 is a core part of the system's checks and balances. It balances the state's undeniable power to prosecute with your fundamental right to due process.
Yeah, the right to only face charges that are legally sound and properly brought forward from the get-go.
Right. Understanding the timing, those critical non-waivable exceptions, and how it differs from provisional dismissal, it really shows the layers of protection built into the process.
It really does. It makes you think about how these, seemingly technical rules are actually the bedrock protecting basic rights and the integrity of the whole justice system.
They're strategic tools for fairness, not just procedural hoops. Essential stuff.